It looks like everyone's here, so I think we're good to get started. Good morning, everyone. Today is Thursday, January 30th, 2025. The time is 9:29 a.m. This is a pre-hearing conference in the matter of Thomas Heller before the Massachusetts Peace Officer Standards and Training Commission. This is a public proceeding and proper notice has been provided. We are convening remotely via Zoom, and this pre-hearing conference is being recorded. The Honorable Charles J. Hely will be the presiding officer over today's pre-hearing conference. My name is Lizzie Smith, and I'm the hearings administrator for the Post Commission, and this matter is now before Judge Hely.
Good morning, Counsel. We have a few things to cover, but it shouldn't take too long. The first thing, at least I'm interested in, and we need to give attendance to, is the Officer Heller's motion to issue subpoena to town of Stoneham and police department. And so if you want to go forward with your arguments on that, Mr. Dioria, if I hope I pronounced your name correctly.
You have, Your Honor.
Then we'll hear from Mr. Hartnett after that. I'm sure I'll have a few questions, but go right ahead.
Sure, Your Honor. By way of background, Your Honor, I had initially requested copies of personnel records, more specifically disciplinary records, internal affairs records of several of the post witnesses, Jonathan Mahoney and a Nathan Powers. Jonathan Mahoney is a former police officer with Stoneham, and Nathan Powers is currently employed as a dispatcher for the town of Stoneham. It's not clear to me whether he's employed by the police department or the town or both. That's why I suggested, two potential sources. In any event, why are these records relevant? Former Officer Mahoney and Nathan Powers are, by my assessment, after having reviewed most of the discovery, the chief accusers of my client. Those two individuals, I would expect, based on the discovery received, are going to claim that he made certain statements and took certain actions. One of our defense theories is that this is retaliatory by them against Heller, who used to be their supervisor. And the allegations against Heller didn't come up, and I'm approximating, until perhaps a year or so after Officer Mahoney was subjected to discipline, and eventually it's not clear to me whether he was terminated by the department or left voluntarily or was forced out. Again, not clear. I don't have that information. So the information I'm looking for goes to their motive to want to retaliate against Heller, who was their supervisor. I know some of the discipline was initiated by Sergeant Heller, although he doesn't mete out discipline, but would report certain things that occurred under his supervision. So I see this evidence, especially in light of the fact that Mahoney is no longer a member of the department. Upon information and belief, he was forced out. I can make a proffer that it's my understanding that he sent emails to the police chief that were vulgar. Upon information and belief, he was physically assaulted a probation officer off duty in a bar room. He was disciplined by Heller for non-performance at different times. So we would like to explore that and understand more specifically what it is that Mahoney did that subjected him to discipline. Nathan Powers, same thing. He was a dispatcher, typically or many times on the shift that Heller supervised, and again had conflicts with Heller. He was reported for various conduct by Heller. Again, it's not clear to me what, if any, discipline was meted out to Dispatcher Powers. So for those reasons, I'd suggest, I guess I'm analogizing this to a Rule 17 motion in district court or a Superior Court motion. It's not a fishing trip, Your Honor. It's, we're looking at evidence that goes directly to their motive to be biased against my client, to retaliate against my client, to manufacture allegations against my client. So it's for those reasons that I see those records as being essential to us providing a defense here.
Mr. Dior, you mentioned a suit by Mahoney against the town of Stoughton.
Yes.
Do you already have access to the complaint?
I do. I have the complaint. In fact, I made reference to that complaint at one point, and I'd be happy to repeat that. This came up at the one of the early proceedings in this case, where Mahoney alleges in his complaint that the incident where Heller allegedly made some crude comments about a female accident victim occurred on a certain date. And he says that in the complaint, which I suggest is a judicial admission. And I suggest that Heller wasn't even working on that date. Okay, but there is a lawsuit. And what Mahoney is alleging essentially in the lawsuit is that he was retaliated against by the town of Stoneham for being a whistleblower. And he accuses Sergeant Heller of being one of the employees of the police department that was retaliating against him for whistleblowing. Other than seeing the complaint, I haven't really seen anything else on the lawsuit. I don't know, for example, whether there have been depositions or interrogatories or anything like that. Those things wouldn't be published typically in the online docket. But I was able to download the complaint. So, and again, that adds to Mahoney is stating in a public document that Heller was one of the people that retaliated against him for whistleblowing. And again, I'd like to see the personnel records of the internal affairs investigations that led to him leaving the department, we believe involuntarily.
Okay. Anything else before we go over to Mr. Hartnett?
That's all I have, Your Honor.
Great, thank you. Okay, Mr. Hartnett.
We don't really object, Your Honor. It's not really our position to object to the substance of the subpoena. I think that the town is well equipped to do that. But he has a right to issue the subpoena. My only concern, just not now, but if this goes on too far, there becomes an undue delay, I think I would maybe reserve a right to bring that up later. Or if for some reason it seemed like it was some sort of undue infringement in the witnesses, I would be concerned. But right now, this is just general questions about the witnesses that seem. I don't have any reason to object to it.
Well, there's a difference between, let's put it this way. If you're subpoenaing the town, what are you going to get? Routine personal stuff, routine administrative stuff, not that personal. You already have the complaint in the lawsuit by Mahoney against the town. So I'm leaning toward, let's leave the town records out of it. And I'm interested in the argument, it's a reasonable argument, certainly, about personal animosity between the witnesses and Mr. Heller. I don't want to make a decision today, but I probably will have a written step-by-step tomorrow. You've got your list of what you're looking for. And I think there's some weight to some of it. And I don't really have anything more to add to that right now. Go ahead.
Just to clarify one point. Yeah. The reason that I included the town, and I understand Your Honor, saying, well, what's the town got to do with it? It's not clear to me who employs the dispatcher. I've listened to a number of statements, and an investigator would ask, and it wasn't clear to me whether dispatcher Powers was a town employee or a police department employee. Again, I'm not looking to go fishing into records of any agency that doesn't employ them. I just included both because I wanted to make sure that I hit the right target, so to speak.
Okay, well, I'll take a good look at it.
Sure.
Anything else, Mr. Hartnett?
No, Your Honor.
Okay, let's see what we can do about scheduling the adjudicatory hearing. I'm sorry I was on a trip week of the 17th, but I'd like to get going. I'm sure you folks would like to get going. And have you talked about possible dates, or if you haven't, or if you have, that's good. If they're coming up soon, if they're too far away, we want to pay attention to the things that are too long delayed. Any comments?
Judge, we spoke last night in anticipation,
Good.
and
Oh, good.
Attorney Hartnett and I talked about, and correct me if I'm wrong, Tim, late March. I know I've got some back-to-back trials really that go through mid-February, right through mid-March, but I do open up that last week of March, and I'm estimating this might be 2 days, but I'm, so I definitely have a window in there. And I think that should give me sufficient time to, assuming that the subpoena motion is allowed, to obtain the records, review them, and be prepared for the hearing.
So you're concerned that you're tied up until the second half of March?
Yeah, just by way, it's I always have a busy schedule, but I'm in Middlesex Superior Court starting a criminal trial on February 10th. And then I'm in Plymouth Superior Court starting, it's a bench trial on February 18th. And then I jump into probably what would be a 2-week trial in March, a civil trial in Middlesex Superior Court.
Is that the first half of March you're talking about? Or
The first half of March, and I really, given the makeup of the trial, I really need some prep time in between to be properly ready. And then I've got trials scheduled on April 3rd and then April 10th. So I'm thinking that last week of March fits pretty well for me. Again, I'm not looking to push this thing way out either. But obviously I want to be, properly prepared to do it the right way as well.
all right, well, let's not rule out the second half of March. I mean, I wouldn't prefer not to push it to the very end of March.
Yeah. I'm open the whole week of the 24th of March.
So this hearing, this adjudicatory hearing couldn't be more than a day, I would think.
Yeah,
Unless,
I was going to say a day or two at most.
unless one of the crucial witness can't be there.
Sure.
Okay, the week of the 24th. Well, thank you for your candor on these things, Mr. Dioria. Mr. Hartnett, do you have conflicts and problems?
I mean, the only conflict I have is the week of President's Day. I'll be out with my child is out of school, is not in school and whatnot.
Are you gone for the whole week, or
I'm gone for that whole week.
okay, so that's
Out of state.
somewhere in the early
That's
half.
in February anyway. So,
Right.
but March is generally fine with me. So that's why the end of March is fine with me.
Okay. Did you gentlemen try to put together a joint pre-hearing memorandum?
We did.
We did not for
already
today,
submitted one?
but we can certainly, and we submitted separate ones before, but I think we could certainly submit a joint one and work towards submitting a joint one sometime between now and the hearing.
Okay.
I think that's
All right. Well, you should at least have in a joint memorandum, pre-hearing memorandum. You don't have to agree on everything, but you probably have an agreement on a witness list. Either one can call his own witnesses, and I'm sure there'll be overlapping. So one start, and if one side or the other comes up with a name for a witness that the opposing party, what's this about? You know, you should work that out. Okay. I had a chance to go over Mr. Heller's motion to issue the subpoena to both the town and to the police department. And I'm going to do some more work on that in terms of narrowing it down. Some of it you will get, Mr. Dioria, because of, as you say, a motive or an animosity or a bias against Officer Heller or Mr. Heller is legitimate evidentiary relevance. It's not going too far or too far back or anything like that. So, but anyway, I should get that in writing out to you folks tomorrow.
Fantastic.
Anything else, Ms. Smith, that we should be trying to cover?
Your Honor, there is one more issue I'd like to
Go ahead.
raise.
Mr. Hartnett, go ahead.
There's a confidentiality issue. Me and counsel had spoken about a potential protective order, but given the nature that I'm trying not to have certain information disclosed, I would ask that maybe we go into a closed session for that issue so that I can be more candid about what the issue is without
Let
disclosing.
me ask this, is it something that I need to be involved in? I'm happy to do what is necessary to case in a proper way, but on the other hand,
I think we'll have an assented to motion to file.
another
We'll have an assented to motion to file, but it may be helpful for you to have more context because given the nature of what it is, I couldn't necessarily put all that information in the motion. So maybe if you may be helpful to hear it from me in a closed session today, but that's your decision.
Okay, so you want to address this today and temporarily keep it confidential?
Yeah, we're not necessarily, and just to let you know what it is so that you have that information in advance of receiving the
So
anticipated.
is that something that we can manage appropriately, Ms. Smith, in terms of temporarily confidential, off the record, or on the record, but not exposed to the public? Is that right?
Yes, so we can either send a separate Zoom link to the parties, or we can just remove the public participants, whatever the parties prefer and think is best.
Yeah, I can say that I think Tim and I have talked, and I think his most recent draft is definitely assented to by me, and I think it might make sense to go into a private session just so Your Honor understands the context of what we're doing.
Okay, is that okay? Can we manage that, Ms. Smith?
Yes, we can do that. And we likely won't have to reconvene in a public session afterwards, correct?
Correct.
Okay, great.
All right.
One thing about scheduling the hearing, did we actually confirm a date yet? I just want to make sure I write it down if we do.
Well, we don't have a date now. Mr. Dioria suggests the best thing for him, or the soonest thing for him, is week of March 24. I take him at his word in terms of being a busy trial attorney.
Judge,
I'm sorry, I'd like to put you through it in February, but I believe the reliability, maybe some of your cases will work out, but you can't count on that for sure. Work out in terms of settlement.
Yeah, as Your Honor knows, I mean, sometimes he settled the day of trial, but I've got to set the time aside, you know.
Yeah, true. Okay, so I don't have anything more for this morning's hearing. I don't mind sticking around for a informal conference on the confidential matter. How's that sound, Ms. Smith?
Yes, that's perfect. I will just send a separate Zoom link to the parties and to you, Judge Hely, and we can get started.
All right, so we'll close this link and I'll get
Yes.
another link in a short while.
Yes, sounds good.
All right, gentlemen, thank you very much. Thank you.
Thank you, Your Honor.
Thank you.
Judge,
No, Your Honor.
I have, oh, I'm sorry, Tim, I didn't mean to interrupt.
Go ahead.
I just have one thing, and I just thought of it, Judge. I did reach out to one person as a potential witness and exchange some emails. And it's an employee of the Stoneham Police Department that indicated she didn't want to come testify. She hasn't refused, but, well, she did. She said she would decline. And, normally in a case, I just serve her with the subpoena. I guess I'm inquiring, I'm not sure I understand the procedure to secure attendance of witnesses at the adjudicatory hearing. Should I be filing a formal motion for a subpoena for this? Again, I'm not looking for documents, just attendance.
Is she local? This
Yeah,
person?
she is. She works for the Stoneham Police Department still.
Is there any reason why that Mr. Hartnett and the commission say this is irrelevant or not permissible or not needed?
No, Your Honor. I mean, she's not a police officer, so I don't necessarily have any jurisdiction over her, so I can't necessarily be.
Slow it down. My hearing is not very good, so slow it down.
She's not a police officer, so I can't help as much as I might be able to help if it was a police officer. But she is apparently a witness for to part of this, so I think it's totally fair game.
She's a potential witness on what subject, or what would you say?
She's in one of the reports. She's identified as a potential witness to one of the things that Mr. Heller allegedly said. So she's clearly relevant.
All right. Well, I don't know if it makes any difference. She's unhappy being called as a witness. I would not have any problem with her testifying remotely. That's the kind of flexibility that we have nowadays with our technology. So that's something that it's not going to make her happy, but it might make her less unhappy.
You're
okay. Yes.
Sorry. Yeah, yes. I was going to say, I'd be happy to send her an email offering that to her as an option. And if she continues to decline, I guess my understanding is that post can subpoena witnesses, but I'm not sure I can without getting Your Honor's blessing to do so. I don't, I'd like to think that she'll come around, but and I'm not sure what her perceptions are of me or where I stand. Nobody wants to come testify. We all know that. Yeah.
Yeah. But do you think she has some relevance to this case?
Yeah, she definitely.
She's the one who was being talked about, but she wasn't present when.
No,
she's apparently witnessed. She apparently witnessed one of the statements. She's
witnessed.
I believe, and correct me if I'm wrong, Attorney Gary.
No, she didn't. That's exactly what I wanted to call her, because I listened to her audio statement she gave to the investigator, and she spoke nothing but good things about Sergeant Heller, and said that while she was dispatching, she never once heard him ever use any type of vulgarity or sexist comment or racial comment. And so I was looking to call her to testify that, okay, over your many years working with them, you never heard or observed him engage in this conduct. And based on the tenor of the email I got, I think she thought that I was looking to subpoena her to say that he did engage in that conduct. And her response to me was that, look, I've never observed him say those things, which is helpful to my client, obviously.
You're keeping the idea open of calling her as a character witness in terms of consistent behavior or lack of abusive behavior.
Yeah, that, but also as a precipient witness in the sense that, the allegations being made that there's a pattern of this type of conduct. And I've got somebody that worked with them frequently over a period of years that never observed it. So I think, yeah, it does kind of overlap with character as well. Sure.
All right. So this potential witness for Mr. Heller is currently a Stoneham police employee.
Yeah, she was a dispatch and she became a records clerk, as I understand it. So she's employed. Again, this is where I get into that I'm not sure where that line is between, is she a town employee or a police department employee?
Okay.
She,
All right. Well, I mean, is there any reason I should not authorize a subpoena to this witness? And yeah. Okay, well,
No, Your Honor, I have no
that's
objection.
off. No, put in your communications with her, the hearing officer says you're a necessary witness. It's not pleasant, but here's your subpoena, and we expect you to attend. And you can attend. You can sweeten it whatever way you can. You know, I'm happy to have her be remote if it's acceptable to you. So I'm glad you brought it up, but that should be workable. So do your subpoena.
I'll offer by remote too.
Pardon?
Just to hope to make things go more smoothly. I'll make that offer to her to appear remote, and if she's not happy with that, then at that point I would ask for a subpoena, and I'll even state in the subpoena, if she so desires, she can testify remotely, and that way we keep everybody happy. Hopefully.
That's fine with me.
Yeah.
You can word the subpoena appropriately. Sure.
Sure.
Okay. Anything else, Counsel? All right.
I'm
Yeah.
all set.
Okay. All right. Thanks very much, Counsel. Thank you.
Thank
Mr.
you, Runner.
All
Thank you,
right.
Your Honor.